And we're on the line again this morning with Marshall Chriswell for another installment of Marshall Law. And this program is intended for informational purposes only. The information does not constitute legal advice. The law is constantly changing, and the information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. Say a guy like Marshall Chriswell, who is on the line with us. Marshall, good morning.
Good morning, Todd.
It's good to have you with us here today. I want to get right into this topic. It's a very serious topic, too, and we can use sort of as a jumping-off point for this an appellate court case that is going through the system, and it has to do with estate planning and the very, very emotional topic of end of care, end of support services for folks who are nearing the end of their lives and then they're survivors. Tell me about that case and tell me what lessons we can pull out of it.
Sure. It's a real difficult case to read, because these topics are so emotional, and dealing with families that are in these situations, I know what they're going through. And but anyway, it's a case out of Bucks County from last year, and the parties are identified in the case by initials, but I'm just going to give them first names. The two siblings, Michael and Catherine, are basically arguing over whether to withdraw life support, withdraw life-sustaining treatment from their 81-year-old mother, who, an 81-year-old widow, we're going to call her Faye. Faye was a very, by all accounts, a very independent person. She lived alone. She still drove. She gardened. She loved to spend time with her family. And unfortunately, on March 17th of last year, she had a fall, and this fall caused a severe brain injury, which put her into a coma. And it's a coma from which she would not recover. But at the time, Michael and Catherine, the siblings here, disagreed over whether she would recover or whether they would withdraw life-sustaining treatment. And it caused, obviously, a major rift between the two of them. Mm-hmm. But also, it was an extremely drawn-out process over a course of about 5.5 months. Initially, Catherine files for an emergency guardianship of her mother, and the fact that she files for that tells us that Faye had no estate planning done at all. She certainly didn't have a health care power of attorney appointing her children or anyone to make health care decisions for her if she was incapacitated. Didn't have an advance directive regarding end-of-life treatment. So this means that somebody has to file with the court, and Catherine, the sister, files for guardianship and also files a petition to withdraw life-sustaining treatment. Goes through a series of procedural machinations and hearings where there's medical testimony given, and basically the testimony is all in line saying that this is a permanent vegetative state. Faye is never going to come out of this coma. She is either going to lay in a hospital bed or she's going to be transferred to a long-term care facility and probably go back and forth between the two for a period of time before she finally would expire. And the brother, just can't let go and can't, and so he fights, and he ultimately can't find a doctor to say what he wants. Catherine prevails. The Orphans Court on May 15th of 2023, so here we are 2 months after the fall happened, and Faye's been laying in a hospital bed for 2 months. Orphans Court in Bucks County rules for Catherine and says, hey, yes, withdraw, so you can withdraw life-sustaining treatment and go from there. Immediately, the brother, Michael, files an appeal to the Superior Court. That's another 3-month process where briefs are filed and decision is made. And finally, on August 22nd, 2023, there is a decision affirming the Orphans Court. The Superior Court, the statewide appellate court in Pennsylvania, affirms the Bucks County decision, and ultimately, Faye is permitted to die peacefully. So, what do we learn here? Number one, I think, this was a really from everything that I've read, this was a really clear-cut case of what they call a persistent vegetative state, where someone really does not have the opportunity to recover. And the fact that there was this difference in opinion between the siblings really prolonged Faye's life when it probably shouldn't have been, and prolonged her suffering. And all of that is because she did not have a plan in place. If she would have had a plan in place and appointed, Catherine, who from the testimony it appears knew her better, I believe, that it seemed they had a stronger relationship and such. She, if she would have appointed Catherine or some other trusted person to make these decisions, it wouldn't have gotten to this point.
Yeah, and that's the big one there, and the idea of an advance directive and its power, especially its power to overtake the wishes of one child or even numerous children, all of the children. Talk about that, if you would, an advance directive. Maybe define what it is first, and then tell us about its specific powers.
Sure. So when I draft these types of documents, I do a healthcare power and advance directive. Generally, in one form, the healthcare power of attorney appoints a child or children to make decisions, medical decisions on your behalf if you become incapacitated or unable to communicate properly. So if you're unconscious, if you've developed dementia, if you're unable to speak or think properly, then this says, okay, this is the child or children I want making these decisions. And often when having these conversations with clients, you're deciding, okay, which child or children are we going to pick? It is very common that someone will say, well, I love my son Michael, but I wouldn't want him making healthcare decisions for me because I know that he would never be able to, quote, pull the plug, right? Mm-hmm. We would never be able to withdraw life support because he's emotional and such. And so, those are common things. And so you have the healthcare power of attorney, and then the other part of that is the advance directive. And the advance directive are the instructions for end-of-life situations. It essentially gives authorization to the doctors, the treating physicians, and your agents under the power of attorney to withhold or withdraw life-sustaining measures if certain conditions are met, right? If you're in an end-stage medical condition where there's no hope of recovery and your death is imminent, in that situation, the document generally says, hey, give me treatment to keep me comfortable, but nothing that's going to artificially prolong my life in that situation.
Yeah, and the interesting thing about it all to me is that when you have something like that worked up ahead of time, you're doing this when you're feeling well, one would assume, or when you are in full control of your faculties and everything is able to be your decision. And when the situation deteriorates and you don't have those abilities and there is so much emotion around it, that's already been taken care of. And so it's really something that people want to avoid thinking about but should think about.
And optimally, the principal, the person making these documents out, is going to discuss with their kids or the other people listed in this document. Hey, this is what I've signed. This is who has the ability to make decisions. And if it gets to the end, this is what I want or don't want to happen. And that's part of the planning process. It's not just coming in here, talking about a plan, reviewing and signing documents. It's also making sure that your loved ones are aware so that there aren't big surprises, because surprises lead to conflict sometimes.
Well, let's think about what happens when we don't do that, and when our family members are left with some really devastating and potentially rift developments. We could avoid all of that, but what happens when we don't do it, when we don't follow through?
Well, you have situations like we had here, and although they aren't all this extreme, you have number one, you create rift in your family, and that's what most people say they want to avoid. Is that they want to avoid any fighting between their children and other loved ones. So that if there is, heaven forbid, this type of litigation, I mean, these people spent thousands, if not tens of thousands of dollars, fighting over this issue. And so that's something that most of the time people are trying to avoid, right? You don't want your family to fight. You don't want them to not get along. And you don't want them to spend all of their money or your money fighting over your care.
And plus, you're lingering for 5 months in this case. And who can say how long somebody would be forced to suffer in some way without something like this being in place?
That's right, and I think a lot of us remember there was the Terry Schiavo case in Florida, which was a similar kind of situation, and that sort of nationally opened a lot of people's eyes to these situations. And I don't remember how long it was that she was, permitted to be in the state she was in. So, months and even sometimes years.
Marshall, are Pennsylvania laws that much different from other states' laws in this respect?
Well, I'm not licensed in other states, so it's difficult to speak on that. From everything that I know, in this particular area, laws are pretty consistent across the board. There have been there's been some movement, but generally fairly consistent. But you certainly when we're talking about the documents themselves, the healthcare power of attorney, the advance directive, or living will, sometimes it's called, those vary from state to state. And that's, if you move from one state to another, I get this question a lot. Somebody says, well, I'm moving to or from Pennsylvania. Should my documents be looked at? Yes, your documents are going to need to be updated. We want them to be the most recent documents, and we want them to comply with state law. And
we're talking here about medical issues and end-of-life types of things that come up for folks in that very stressful situation. But do people actually take this situation, combine it with their property disbursement and their estate plans as a whole, and make them into one big package? Well,
absolutely. I always, if somebody comes into me and says, "Hey, I just need a simple will," I'm always going to recommend that we not only do a will, but we also deal with financial power of attorney and healthcare power of attorney, because you really need all three of them to have a complete estate plan.
Yeah, and somebody working in that capacity or in that direction probably also wants to get in touch with their funeral provider as well and put them all together.
Oh, sure. I mean, those are things that we always talk about at our estate plan consultations, is, that not only do we need to take care of the legal part of this, you also need to take care of the practical part. And pre-planning and prepaying, if you can, for final arrangements, funeral arrangements, is a huge gift that you can give to your family. And there are lots of other practical things you can do, information that you want to make sure to gather and have for the kids in the event that you get sick, you get hurt, that they can jump in and sort of handle things as best, to have some better information. And there are lots of practical considerations as well as legal.
That's a good way to put it, too. It's a gift for your family. All right, so Marshall, if somebody wants to get started on this with you, what should they do?
You can always give me a call. The number is 724-465-5826. Stop and see me. I'm in the R&P Cole Building, which is behind the post office. It's at 655 Church Street here in Indiana. Or go online to the website, drop us a line there, www.westernpalawyer.com.
He is Marshall Chriswell, and thanks so much for joining us today.
Thanks, Todd. Take care.
You too.